I want to thank everybody for coming tonight. And I'll tell you who I am and what we're doing and introduce the speakers. And then we'll have time at the end to have questions and answers. We have the space until 9 o'clock. So to start, my name is Mary Menapace, and I am a nurse, and I live over in Skaneateles. And as a public health professional, I got interested in hydrofracking on a public health and environmental health issue. And so I work with several different groups. And the group that's sponsoring this tonight is GDAC, Gas Drilling Awareness of Cortland County. But before we begin, I want to say a big, huge thank you to Carrie Idell and Peter and Angela and the folks here at Auburn Public Theater because they donated this space for us tonight, which is a beautiful thing. And it would be, if you live in the area, I highly advise you to go on the website for Auburn Public Theater or sign the clipboard out by the bar, because this little theater does amazing things. They have all kinds of workshops, they do lectures, they do all kinds of music, they do film and comedy, and it's a great little theater for our town to have, and it's actually become quite a big venue. So I thank Carrie, and I'd like to just give him a round of applause for donating this space. Thanks, Carrie, wherever you are. So, natural gas extraction, it's a big, huge, complicated issue. And I've been studying it as fast and as furious as I can for the last couple of years. And to understand it, you have to understand global energy markets, international trade, climate concerns on a planet scale, federal laws, federal energy policy, state oversight and regulation, and on a community scale, the towns, the little towns and the rural areas that we live in here in central New York, we're grappling with issues, economic impacts, positive and negative, environmental impacts, of course, positive and negative, well, environmental impacts, that's all I'll say, social issues, and the rights of towns to control development and the rights of individual landowners to develop their land. So there's lots of sticky, controversial issues. Tonight, the piece that we're going to deal with is a basic piece. A person owns a piece of land and makes a contract with an energy company to drill for natural gas. And that's, we're going to cover gas leases. And specifically terminating a gas lease, a lot of the leases around here were signed about a half a decade ago and they're coming up. And we have two gentlemen that have extensive knowledge, done extensive research and extensive knowledge on this issue. Joe Heath, who is an attorney, and Mike Bassetti, who is a landowner. And Mike's going to come up and speak first. Mike owns 40 acres down in Marathon, New York, and his lease is one of the first ones that has come up, and he successfully terminated his lease recently. And I have to say, Mike isn't just a landowner, he's an activist on this issue. He's done extensive research. Gas Drilling Awareness of Cortland County, who organized this symposium tonight, is an amazing group of people that have devoted a lot of their time and a lot of their life the past few years to understand this issue and how it fits in with our beautiful area here in the Finger Lakes in central New York. And I drive from Skaneateles all the way down to Cortland because they're really intelligent and they do stuff. So they're the ones that organized tonight. And Mike is a part of that, and Mike was a part of a project that I work with him on to raise awareness in the medical community of the potential health impacts and the real health impacts. So again, Mike owns 40 acres down in Marathon and recently had his gas lease expired, and that was not an easy thing. So he'll tell you about that, and then we'll hear from Joe.
Well, as Mary said, I just terminated my lease about a month ago, and I'm going to share with you what I learned from that experience. Getting my brain around the scope of all of this was an important part of my learning curve. So first I'm going to try to frame the leasing issue in a broader context. Then I'll give you a preview of some important things you should keep in mind when you begin the process of terminating your own lease. Then I'll talk about the public records search, which is something you'll have to do to learn what other gas companies have a working interest in your property. Then I'll read my own history of lease assignments to you, which probably will drive home the point how convoluted this whole thing really is. So I'm going to begin with this first slide, land grab. This characterization by Andrew Cuomo was a red flag for me. Many of these companies use their size and extensive resources to manipulate individual property owners who often cannot afford to hire a private attorney. This land grab practice must stop. That was from a Binghamton News story from November 2009 in reference to the settlement the Attorney General's office reached with Fortuna regarding Fortuna's attempts to fraudulently extend leases. Now, this battle continues today, this time with Chesapeake Energy. As many of you may know, Chesapeake is aggressively trying to extend their leases. This is a lease map of the town of Onondaga, and not all of Onondaga County. I'll get to that in a second. There was no lease map available to me of Cayuga County, so I went to the county clerk's website and gathered this information. In Cayuga County, Chesapeake has 662 leases recorded in the office there. Phillips Production Company is named 7 times in Summerhill. Fortuna has 2 listings. Columbia Natural Resources has 160 listings, but these may be included with the Chesapeake leases because Chesapeake acquired Columbia. A few Chesapeake leases are assigned to State Oil Hydro in Summerhill and Sempronius. There may be many more of these particular assignments that have not been recorded yet. And you should remember this, because documents don't get recorded right away. You may need to check back to see what's actually on record. It's not possible to tell from the online listings if any of these leases are related by assignment or transfer. The only way to know for certain which companies have a working interest in your property is to check the public record for your property. Chesapeake has over 600 leases in Onondaga County. On this map here, these are only 200 of them. There's 400 more, and they're all south and west of this area. In Cortland County, Chesapeake has 2,386 leases. This is just over half the land in the county. In the past few years, the gas industry has been quietly acquiring thousands of lease agreements encompassing hundreds of thousands of rural acreage across several states. This is not about a few sporadic gas wells. This is about profit-driven multinational corporations who want to fully develop the Marcellus, the Utica, and other formations for generations to come. We call our home the Finger Lakes region. To them, it's a gas field. Leases run with the land. Once a property owner signs an agreement, that contract gets passed along to subsequent owners of the property. Moreover, the amount of land under lease will impact how much other unleased adjacent land will get compulsory integrated or taken by eminent domain for laying pipelines. Because we can't use gas without pipelines. We're also seeing more often now sellers who retain the subsurface mineral rights of the land they are selling. It's a split estate, just like the movie. Many people who have signed the so-called standard industry lease now believe they were duped into signing because the known risk to public health and the environmental impacts were not disclosed by the landmen. State legislators have indicated to me that they will not intervene on these contracts, even if they were acquired in bad faith. And the Attorney General's office is telling these landowners it's buyer beware. So when Andrew Cuomo calls it a land grab, he's not kidding. It's our land that's getting grabbed up by these multinational corporations. It's our land and water being put at risk. And when something goes wrong, it'll be our problem. Here's some important points to remember. First, you should understand that just because the expiration date printed on your lease has passed, that does not mean that your lease is terminated. And second, whether your lease has expired or you received an extension letter, in either case, you must assert your rights by making your position known to the gas companies. This communication is related to a legal consideration called latches, L-A-C-H-E-S, if you want to look that up. So if your lease has expired, you must send a termination letter 30 days after the expiration date. Or if you received an extension letter, you must promptly respond to the company, letting them know you disagree with the extension. On the last page of your lease, above the signatures, you'll see this sentence in bold print. If this lease becomes forfeited, terminated, or expires, the lessee, or if the lease has been assigned, the assignee, is required to provide a document canceling the lease as of the record at no cost to the current landowner. If the lessee or assignee fails to cancel the lease, the current landowner may compel the cancellation pursuant to Section 15304 of the General Obligation Law. Now, to clarify who's who, the lessor is the landowner. The lessee is the gas company. And the assignee is another gas company who has made a deal with the first gas company to share a working interest in your property. Now, the companies probably won't send this document, and instead, you'll have to compel the cancellation by following the 15304 law. You should read this law several times, understand every word of it, and follow it carefully. This law is as biased towards the industry as the standard industry lease. You can read this law at the GDAC website, which is going to come up at the end of this slide thing I'm doing. Or you can just Google New York General Obligations Law 15304 and you'll find it. So now comes the tricky part, the public record search. The gas companies will not inform you of assignments or transfers of your lease. You'll need to carefully search the public records in the county clerk's office to learn which gas companies have a working interest in your property. It's like a shell game for the landowner. You may think that your lease is with the one company that is sending you the delay rental payments, but that may not be the case. I was totally unaware that Fortuna had a 50% working interest in my property during the time I was receiving my delay rental checks from Chesapeake. Likewise, it was a surprise to discover that Chesapeake had assigned 32.5% of its interest in all their Cortland County leases to the Norwegian energy giant State Oil Hydro. Over the course of my 10-year lease, 8 different companies had a working interest in my property. On the advice of the State Attorney General's office, I needed to send termination letters to all 8 of them to be safe. Fortuna changed its name to Talisman, but still operates under both names, and I was advised to send my letter to both at 2 different addresses. In some instances, there's confusion who owns what and what land parcels are actually under lease. Some of this confusion is due to outdated tax map numbers resulting from normal real estate sales. I bought my land in 2003, yet as late as 2010, there was no direct reference to my lease filed under my own name. The lease and assignments were filed and linked by a document number under the name of the original lessor and the gas companies. Both the county and company records may not be entirely caught up with where things actually stand, but it all seems to be organized around the original lease and document number. And as far as preparing your termination letter, you should go with what is actually recorded in the public record. In Cortland, a subcontracting company called Mason-Dixon has a person in the clerk's office specifically sorting this out. The companies sometimes even need to clarify ownership among themselves, called a stipulation of interest. I went to the website for the Cayuga County Clerk and gathered this information to give you here tonight. The clerk's website directs you to landaccess.com, where you can see a listing of documents of record. However, one must pay to view an entire document at this website, and accuracy is not guaranteed, probably in part because of the confusion I just mentioned. I'd strongly recommend you do your search at the county clerk's office where you can ask for help. Now, you can view an entire document from the public computer in the clerk's office without paying for it. Leases are not always linked back to the original lessor, so in some cases you may need to trace the property history. Once recorded by the clerk's office, each document is given book and page numbers. These numbers are useful to individuals who want to look up or research recorded documents. You may get better search results if you do not refine your search to a particular document type, like lease or agreement. Instead, choose all document types, and then enter the gas company name and click on the search button. Inconsistencies with what a document gets called and filed as are another part of the confusion. Make sure the clerk is clear that you're recording a gas lease termination. Mine was inadvertently recorded as an affidavit and was not linked to the original lease. But they were very helpful in Cortland about correcting that. I guess I can leave this up for a second. I'm going to give you a rundown of my lease history now. This is really hard to follow. Just try to get the gist of it. Pay attention to the frequency of the assignments, the number of companies involved, the name changes. If you have a lease with Phillips Production Company, you may find pretty much what I'm going to read to you. If your lease begins with Chesapeake, probably half of what I'm going to tell you, the second half from 2005 till now, might be applicable to you. So November 2000, the original lease was executed with Phillips Production Company and a property owner who I never knew. August 2002, Phillips assigns a 50% working interest to Triana Energy Incorporated. June 2003, Phillips assigns another 50% working interest to Triana. So it looked like 50% of what they still had got assigned. A year later, actually 6 months later, January 2004, there was a recording of an affidavit of conversion of Columbia Natural Resources Incorporated to Columbia Natural Resources LLC, and merger of Triana Energy Inc. into Columbia Natural Resources LLC, making Columbia LLC successor in title to Triana by merger. February 2005, a stipulation of interest and cross-conveyance is recorded to clarify that Phillips and Columbia each has a 50% working interest. This is because of that 50% of 50% that I mentioned a minute ago. A few months later, in 2005, I got a letter from Columbia informing me that they chose to extend my lease for a second 5-year term. This letter states that Phillips assigned its remaining 50% interest to Columbia in June 2004. That's not right. It's inconsistent with the record. In fact, Phillips assigned its remaining 50% to Fortuna in 2006. So I don't know, they clearly didn't understand what they were telling me. In 2005, backtrack a year now, Chesapeake begins acquiring Columbia Natural Resources. Skip ahead now, 2007. The Phillips Fortuna assignment gets recorded at the Cortland County Clerk's Office. This is 10 months after the assignment was actually dated. So when I mentioned earlier about checking back, this is what I was referring to. November 2008 now. Chesapeake records an assignment and conveyance of 32.5% interest to State Oil Hydro USA Onshore Properties Incorporated. This is a mass assignment applicable to all of their Cortland County leases. There's 34 pages of leases that got assigned in one recording.
You said that name again for the state?
State Oil Hydro USA Onshore Properties. A year after that, now we're November 2009, State Oil Hydro USA Onshore Properties changes its name to State Oil ASA. A month later, January 1, 2010, Fortuna changes its name to Talisman Energy USA. November 2010, Chesapeake finishes acquisition of Columbia Natural Resources. So that took 5 years. November 2010, expiration date of my lease. At this point, the record shows my lease to be in the hands of Chesapeake, State Oil Hydro, and Fortuna. March 18th, I finally am able to record my termination letters. And then 10 days after that, Chesapeake sends me a release, the one that they could have sent 4 months earlier, signed by Chesapeake and State Oil Hydro. I never received anything from Fortuna. And then just sort of, it's almost laughable at this point, just a couple of days ago, Talisman called me. They couldn't find any reference to my lease. So I hope this was helpful to you. I did bring copies of some of my documents that you can see if you'd like at the end of the presentation. I brought my termination letter, the affidavit of service, the release from Chesapeake, and also my lease history that I just read off to you. So with that, I'll turn it over to Joe. Thank you.
Treaty rights, land rights, and excise tax issues. In addition to these current areas of work, Joe has extensive experience in social justice legal work. Civil rights litigation, Joe worked on the Attica Civil Rights class action case for 29 years before it settled in 2000 for $12 million. Joe's worked on constitutional law and protection of free speech and assembly, criminal defense and trials, and Joe's worked for the protection of abused and neglected children and in the area of domestic violence. Joe's also an active member of Veterans for Peace. So Joe will share his experience here with us.
Well, thank you all for coming. As Mike has explained to you, you cannot assume that your lease ends just because it says that it's supposed to end on a certain date. So what I want to go over tonight is I really want to stress that you want to think very carefully about extending an existing lease, whether you want to lease again or whether you want to end it. All of these leases, most of the leases, at least in Cortland County, I'll show you that I live in the northern part of Cortland County in a minute, most of them were signed in 2006, and so they're set to expire this year. Back in 2006, none of us knew very much about gas drilling. We thought it was a little gas well that we call them your grandfather's gas well. And the word among particularly the people that I know in Cortland and Onondaga County was, well, this is pretty easy money, they don't do anything, and it's a safe thing, and most people just signed it without really understanding everything that was in the lease or what was going to come 5 years later when we now know so much about hydrofracking and all of the dangers that that presents. And these old leases have very unfavorable terms, both monetarily and in what the companies are allowed to do, almost no control over where they locate things. The finances have changed radically. The rates that were given 5 years ago have grown exponentially. So the main thing that we want to get across to you tonight is your lease will not automatically terminate. And you must take steps, and we'll cover those, I'll cover those in a minute with some law and procedure. Mike touched upon them. I'll go into it a little more detail. Because what we've seen is that the companies are now trying to extend their leases. If any of you have a Chesapeake lease, it's very likely that you received a letter dated January 26th that claims to be able to extend your lease by what is called force majeure. That's a legal term. We'll come back to that. They seem to have sent them to everybody in Cortland and Onondaga County. And there are reasons that most lawyers that are familiar with this area don't feel that that claim is valid. But I know from talking with neighbors that it's a very, very emotional thing when you think your lease is going to end in May, and then you get this letter and all of a sudden they're claiming, no, your lease doesn't end. We'll go over how to respond to that. There's a concept called delay rentals, which you must be very careful about. And leases that I've seen that are more recent now have a non-termination clause, very cleverly worded. Obviously, these companies have signed thousands or tens of thousands, in the case of Chesapeake, probably hundreds of thousands of leases. They've been involved in dozens of lawsuits in various states, and they've learned all the tricks. So this would be like trying to play poker when you've never seen a deck of cards before against a master, because they know what they're doing, and we'll come back to some of the other tricks that they use. So this is a map of the shale formations in the United States, and they're drilling in many of these. This is the Barnett Shale in Texas. This red area here is a combination of the Marcellus and the Utica Shale. We always hear a lot about the Marcellus Shale, but there's a deeper layer of shale in I don't know whether I have those maps in this. Yes, I do. This is the Marcellus Shale formation, and you probably can't read these numbers, but it's relatively shallow by the time it doesn't even extend into northern Cayuga County, and it's too shallow in Cortland County for them to frack. We had a driller come to the Cortland group in December of 2009 and tell us, you don't have to worry about them drilling here because the Marcellus Shale is too shallow. And more I hear that the landmen, the people that get the leases, and the drillers are always saying, we're not going to drill here. It seems to be a standard line. So don't worry about it. You know, there's nothing to worry about. Well, if they're not going to drill, why are they paying lease money? And one of the ways to understand how inaccurate that driller statement was is to see that this is the Utica Shale. Several thousand feet deeper than the Marcellus Shale. It's about 4,000 feet here, 3,000 here, more than deep enough for them to drill here. And that's what they're going to drill into around here. Since Mike started talking to me about his ordeal starting last November, and we've taken a more careful look at lease termination and extensions, I've probably looked at 50 to 60 leases, talked with several dozen leaseholders, and almost every one of them feels personally bad, guilty, foolish for signing their lease, because those are the kinds of reactions that I've seen. How could I do this to my neighbors? How could I give all this away? What was I doing? Well, you shouldn't feel that way. This is let me see if I can skip ahead of that. I'll come back to those lease maps. Recently, in Ohio, a landman's talking point, so really crib sheet, was left in a driveway of somebody that he was trying to lease from. These are direct quotes from what these landmen are trained to do when they come to your door. And we've paid for an analysis of Ohio and its people, so use that data. So you have very clever large corporations using psychologists, polling data, and this is a very sophisticated process to get you to sign that lease. It's critical to obtain the lease signature in the first meeting, or at least the agreement to sign, and take the lease to the notary. Drive them to the notary if you have to. If they have time to think it over, they're more likely to decline the offer. In other words, keep the rush up. Most landowners do not know the difference between hydraulic fracking and the process of slickwater hydraulic fracking. These new horizontally drilled, high-volume slickwater hydraulically fractured wells use up to 7.8 millions of gallons of water each frac. The old fracking that they talk about having done for some years in New York were the vertical wells. Now they can drill down about 5,000, 7,000, 9,000 feet, then turn their drilling horizontally so that they can travel out a mile in the shale formation, and then use all that water, extensive chemicals, under high pressure to break up the rock. That's what's so different about this new technique. It was being used out west, but I don't think there were a handful of people in New York State that knew what it was prior to 2008. And so they know that, and they try to take advantage of that. Use that to your advantage. That's what the landmen are told. If anybody knows about slick water fracking, just avoid the topic. Do not discuss the chemicals. If I were them, I wouldn't discuss the chemicals either. And do not mention water contamination in Pennsylvania. Some of you may know that there was a major well blowout last Tuesday in Leroy, Pennsylvania, where Chesapeake lost complete control of one of their wells during a frack process, and the fracking chemicals flowed out for 2 days until they brought in a company that's owned by Halliburton to cap the well. They don't want you to know that that's going on down in Pennsylvania. They don't want to talk about the water usage, and they don't want you to know that your lease allows them to take water from your land, as much water as they want. We'll come back to that in a minute. Don't talk about radioactivity. Reports have shown that fracking has increased radioactivity in the groundwater. While this is true, ensure the landowners that we use no radioactive materials. Well, that's true. The problem is that the shale is naturally radioactive, and the water that comes back out of the Marcellus and Utica shale is radioactive. So the way to get around that is to just say, tell them that we're radioactive free, and that should alleviate those fears. Get the lease signed. If the landowner is undecided, offer them a little more money. Tell them that their neighbors have signed, all of their neighbors, even if it's not true. This will often push an undecided landowner in favor of signing. They will not know if their neighbors have signed. So let me go back. This is the same map of Cortland County that Mike showed you before. I live up here on one of the glacial kettle lakes, heavily leased by Chesapeake. And the green areas on this map are state forests, but as the other map showed, the state is now leasing state forests, not all of them. But this is a map compiled by the Cortland County Planning Department. It's 48% of the land in the county, even though it's only 8% of the landowners. And what concerns many of us in Cortland County is that this is a sole source aquifer. Here's the same lakes up here, the city of Cortland down here, 50 to 80,000 people. That's the only source of water that we have. My private well goes into that aquifer. One mistake in that aquifer, and 50,000 of us will not have water. So let's go back. So you should not feel badly about signing a lease, because you have been the victim of a very, very clever industry. And to these companies, these leases are as much about investment, building a financial portfolio, as they are about gaining any of the gas. The best example that I know of that is that Chesapeake just sold all of their interest in the Fayette Shale in Arkansas for $4.75 billion to a Australian company. So they take everybody's little lease, bundled them together, and sold it for billions of dollars so that they could continue on in this industry. So these are very, very serious major international corporations. As Mike said, there's at least 2 Norwegian corporations that have bought into the leases in Cortland County. And now what the companies are applying for permission to do is ship the gas overseas, because they can sell it for twice as much as they can get here. So all of those stories about energy independence, you should look behind them. So one of the things that I want to do is, when you're thinking about your current lease or thinking about a new one, is you really need to pay attention to what is almost always the first paragraph of your lease. It's called the leasing clause, because it's in there that you have agreed that the companies can do all of the things that we're going to see in the next few slides. And this is, I'm sure, for those of you that had leases, they brought this standard lease to your home and essentially told you that this is what you had to take or leave. So the landowner hereby agrees to give to the company all the oil and gas and their constituents, whether hydrocarbon or non-hydrocarbon, underlying the land, together with the exclusive rights as necessary, convenient at its election. That's pretty what you thought you were giving. Explore, develop, produce, measure, all of that. Using methods and techniques which are not restricted to current technology. That means they can do it any way they dream up. And of course you allow them to drill, maintain, operate, cease, plug, abandon, or remove wells. Also, almost every lease allows them to put a road where they want to, electric power, telephone facilities, data acquisition, compression stations. These are major problems with the leakage of methane and other volatile organic chemicals. Most people did not think they were giving the permission to give compression stations. Including the right to use oil and gas, those we would expect, non-domestic water sources. What that means is that as long as it's not out of your private well, if it's out of a stream, a pond, an aquifer, they're going to take that water and use as much as they want to at no cost. This is the one that most people don't know, and it's in almost every lease I've seen, that you agree to allow them to store gas under your property, whether it's from your property, from neighboring property, from Pennsylvania, from Ohio. This is a seasonal business. They have to store it. There's quite a controversy over in Watkins Glen about a storage facility there. Most people do not want to agree to that clause. Now, and if you're thinking about releasing, you certainly want to take a look at some of these things that they've asked for. So that's the first paragraph. You really want to look at what is in there. The other portions of the lease that require particular attention is that first paragraph, the extension clause. Some leases, the old one that Mike inherited or acquired, had an automatic extension after 5 years. That is in the standard lease. And I've seen a lot of times where people have crossed that out. I certainly would do that if I were signing a lease. Whether or not there's a force majeure clause, again, we'll come back to that. Whether or not there's a delay rental payment, that's where at the end of the lease, they can send you a check and automatically renew and extend the lease. So if you get any checks towards the end of the lease, do not cash them. Send them back and reject them. The other way they extend leases is if they come on your land and conduct what is called operations, which has a very broad definition. Generally, what that's meant to mean, although they go beyond it sometimes, is that if they drill a well and it's producing gas, then your lease extends. So those are the kinds of things to look in leases. And I'm going to try to walk you through the New York State law that governs the termination of leases. Mike talked about it before. Now, I'm going to give you some of the language and to some extent be a little repetitive of some of the stuff that Mike said. So the first section, and I think this law needs major amendment. We've talked to some people in the legislature about this. We're going to the Albany on Friday to talk with the Attorney General. And I think you may see why before we're done here. So most leases say you signed them on May 6, 2006. It has a termination date on May 11, 2011, and you think that's when it's over. But as Mike said, it isn't over. The law requires them that when the lease expires on its own terms, the company or anybody they've assigned it to, and that roulette that they played with Mike's lease is not uncommon, and they're selling these things and parsing off portions of it, and we'll come back to how much difficulty that can cause you in just a minute. So the company is supposed to provide you with a recordable document that would cancel the lease, and you can then take that to the county clerk. We're not seeing those from any company. So then the second portion, the second paragraph of the law says, if the company fails to cancel the lease, as they should have, then you can send them a notice letter. You have to send that to the original leasee, the company and if an actual or record notice of their identity exists, the assignee. So all of those companies that bought portions of Mike's lease had to be notified by Mike in order for him to go through the termination process. Now, all of this, we have all of this on the GDAC website, and that'll come up towards the end. We have sample notice letters, because these letters have to be incredibly detailed. It's not, and one of the things that I think the state should do is just tell landowners, send the letter to the company, attach your lease. That should be enough. You shouldn't have to go through some of these things because it's very, very detailed. But we have sample letters on the website, and we hope that they're user-friendly. So you have to send that by certified mail, and then you want to make an affidavit of service. That's just a statement that says, on such and such a date, I sent this letter to Chesapeake or Cabot or whomever. We have sample affidavits of service in the packet as well. And some of the things that you have to put in there, it really wouldn't do me any good to list them tonight because they're so detailed. Who are the current landowners? All sorts of details about it. They're certainly, you can find these details, but it's very, very burdensome. And the problem with the assignees is that you won't have notice of them. They don't tell you that they've sold any portion of your lease. Sometimes they do, but almost never do they. And the way the law reads is that if they've done what they did what Chesapeake did in Cortland County, file one assignment that says we assign 32.5% of all of our leases to this Norwegian company, and then list all the leases, that document goes in the clerk's office but doesn't go to any of those landowners. So you don't know that there's another company that has an interest, and if you don't notify that assignee, you've missed a step in this process, and your termination may not be valid. So that's a very tricky term. We're trying to get that changed. So once you send them that notice letter, they have 30 days to respond. In that 30 days, they can file an affidavit with the county clerk and merely say, we think the lease is extended. We don't think this lease is terminated. It doesn't have to have any specificity, no legal weight. All they have to do is file an affidavit, and your lease is extended pursuant to this law. We're trying to get that changed as well. Clearly, they should have to at least detail why that is. If they fail to act in that 30 days, then you can file the notice letter and the affidavit of service with the county clerk. That terminates your lease. And here it is again, that every assignee must be notified. You won't get notice of that. We just went over that. There have been articles in the Cortland Standard back in February and the Post Standard. So that's the GDAC website, gdac.wordpress.com. That's Gas Drilling Awareness of Cortland County. It has instructions and explanations, some excerpts from the General Obligations Law, a sample notice letter to companies, and an affidavit of service. So hopefully with those, you can send the notice letter. Again, you want to be very careful of checks towards the end of the lease. Do not accept them, return them, keep copies, send them a letter saying you're not accepting this check. At that point, you might think about getting legal advice. Now let's go back to force majeure, because that's what some companies anyway, particularly Chesapeake, have, as I said, they sent out a letter to every one of their lease holders in late January claiming that they could extend the lease because of the state moratorium. This is a term of contract art that generally it's a French term that means a greater force. If I have a contract with you to build you a house and I can't get to it because there's a flood, or I can't dig the foundation because it's raining every day, that's an act of God that prevents me from complying with my contract obligations. That's what it's meant to be. If there's a strike at the window company and I can't get the windows, the contract gets extended. That's what it's supposed to be. They have turned it on its head and said that the current state moratorium allows them to extend the leases. There are many reasons why this is not valid. Almost every lawyer that I've talked to in this area feels they're not valid. Representative of the State Attorney General says it's not valid. There's a federal lawsuit in Binghamton that was beginning to touch on it. And if you received a force majeure letter, you should send them a letter back. We have a relatively detailed sample letter on the website again. If you don't, they could use your silence against you when your lease terminates. They're not prohibited from drilling for gas in New York State under the current moratorium. The only thing that this moratorium that was enacted by Governor Patterson by executive order back in December and runs till June is that they can't do high volume slickwater horizontal fracking in the Marcellus Shale. They can do vertical, at least using the generic environmental impact statement. And I'll come back to that in a minute. They can do vertical wells. They can go into any other formation. They can go down into the Utica. They can go into the Trenton Brack River. If they want to go in the Marcellus, all they have to do is file a site-specific environmental statement, and they could apply for a permit that way. So they're not prohibited from drilling, and yet they're using this to their advantage. The generic environmental impact statement, by the way, that's how all gas wells are permitted in New York State. It's harder to site a wind farm than it is a gas well. Because every wind farm, there's a lot of local control over it, and you have to do site-specific environmental impact statements. The use of the generic environmental impact statement should not be allowed in this practice. It deprives neighbors and towns of notice. There's no public hearing. All they do is fill out an elaborate form. If they check off all the right boxes and have their engineers say the right thing, they're going to get their permits. Every one of these wells is different. Every location is different. The water, the drainage, there's somebody trying to put a major subdivision near my house in my town of Preble. They have to go through more to do that, to build a 5-house subdivision than the gas companies have to put one of these large industrial drilling operations in your town. That should be changed as well. So they can still, I think I've already gone through all of those. The other reason is, why did they wait 3 years? They haven't been able to do high volume horizontal fracking in New York since June of 2008. It never specifies what they're prevented from doing. At least 2 of my relatively good friends over in the town of Marcellus have leases with no force majeure contract with Chesapeake, and they still got the letter. So they just sent them out because it's easy for them. Other terms that you may want to think about later on if you're going to continue with a lease or renew a lease are pooling and compulsory integration. That's where once they lease 60% of the land in a spacing unit, a unit that they define. They can drill anywhere underneath anybody's land, including your land, whether you've leased or not. The operations, one of the ways to extend your lease, if there is a pooling, is that if they drill or conduct operations anywhere in the pooled unit, that will extend your lease. There's a new automatic termination clause in many new leases. This should not be agreed to. The leases shall be construed against termination. In other words, you can't end it. You want to be very concerned about insurance. Much of the liability from this industrial operation is not covered by your standard homeowner's policy. It's specifically excluded. Landowner liability is a very serious problem. In the southern tier now, they're leasing for $5,000 to $6,000 an acre for land that they could buy for $1,000. And the reason for that is that they would then have all the liability. A number of mortgage lenders will not issue a mortgage if you have a gas and oil lease. You need to be concerned about these things. So let's just sum up and then we'll take some questions. You want to watch out for delayed rental payments. You don't want to take a check towards the end. If you get a force majeure letter, you should respond. It does not automatically extend your lease, no matter how much they want to try to intimidate you with the letter. You have to watch out for assignments, and as Mike says, you need to go to the county clerk and find out if it's been assigned. And you must act at the end of the lease. So that's places where you can get help. That's the GDAC website again. There's an organization in Ithaca called Fleeced, which are people that have leased that are trying to understand what rights they have. There are some landowners coalitions. There are lawyers, particularly in the Binghamton area, that specialize in leasing. And that's my email as well. So with that, we'll take your questions. Thank you for listening.
I have a mic here. Thanks, Joe and Mike. And I just want to say all of their research and all the time on this has been pro bono, and they share it generously. So thank you for that. Okay, so I'm going to bring the mic around if anyone wants to ask questions.
And I'm very hard of hearing, so.
So when you ask a question, if you could introduce yourself quickly.
My name is Faye Gugakis. I'm from the city of Ithaca. I'm not a landowner or leasee, but I'm very concerned about the whole issue, especially the contamination of public water supply. And that's how it kind of relates to me, even though I don't have land. But I care about what other people are going through as well. What I wanted to say first is I wanted to thank you for giving of your time and what you're doing, because part of the reason I came here tonight is I know people that are leased, especially an organic farmer, who said to me, well, you know, I can't wait for my lease to be up because then I'm off the hook. I'm free, you know. And this is very important what you just said tonight, because a lot of people probably don't know that information, that the lease might be, you know, will expire and then they don't do anything, especially the issue of certified mail. That I thought was a very good point. What I wanted to ask you is a little going back and trying to understand a little bit the force majeure. So, in other words, if your lease is up, then if your lease is up, then there's no way for them to extend it. You're saying you could just end it there. I'm not exactly sure what force majeure means.
Well, what Chesapeake and other companies have done have sent out letters saying that they, in their opinion, the leases are extended because of force majeure and the moratorium. That alone does not extend the lease. What they would have to do is, after the lease has ended by its date, let's say the May 6, 2011, we'll try to use that date to simplify things here. Say I have a lease that says it expires then. If they don't send me that cancellation notice, I then send them my notice letter. They can file an affidavit in the county clerk claiming to extend the lease. That's what they would have to do. At that point, the landowner would have to sue in order to end the lease. Now, there are companies, some of the leases in the southern tier are enough older where there are lawyers now soliciting clients to bring not class action, because but multiple plaintiff lawsuits to test that theory, to test whether or not there's really the grounds for force majeure in New York. So our advice is, if you get that letter, answer it, tell them that and what the letter on the website says is, we reject your claim of force majeure. Then go through the process that Mike and I have described of notifying them and see whether or not they file an affidavit. Because if the letter itself doesn't extend your lease, they almost undoubtedly will not send a cancellation notice, and then you must act to try to extend your lease and figure out whether they're going to claim that it's extended. Hopefully, within a few months, we'll have some legal rulings that will give us guidance. One of the things we're going to talk about Friday with the Attorney General is, do they have an opinion? A couple of years ago, when that Cuomo quote arose, when he was Attorney General, he forced, was it Fortuna? Yes. To stop claiming force majeure because their leases didn't even have it in their leases. They've been talking with Chesapeake for a year and a half. Chesapeake won't budge on it. So that's an issue that unfortunately is going to have to be decided in the courts, hopefully not by every landowner that's the victim of it. Hopefully there'll be some guidance from the courts and we'll know that it's not legal. And then it may be a little easier to terminate these leases. I hope that answers it.
Has anybody lost, like, has anybody went to sue them and try to terminate the lease when force majeure was still happen? Like, in other words...
No, there's no favorable ruling for a gas company that says that there's a proper invocation of force majeure in New York. There was a ruling close to force majeure on May 23rd in Binghamton, but that had more to do with a different type of delay rental. Old leases, and I don't see them much anymore, the idea of a gas lease is that they're supposed to come in and drill, not just sit around and do nothing. And so a lot of the old leases, the ones that were interpreted in the Weiser case, that's one of the names of the plaintiffs, it had a clause that says if they don't drill in the first year, they have to send you a delay rental payment to keep the lease going into the second year, and so on throughout the term of the lease. If they fail to make that payment, the lease automatically terminates. It's actually some fairly good language for the landowner. I forget the company there. I don't want to keep saying Chesapeake all the time. So the gas company, in that case, did not make the last year's delay rental payment and instead sent a force majeure letter. The judge said, whether or not force majeure applies or not, so he didn't rule on it, because you didn't make the rental payment, and the term of the lease is very clear that when you don't, it ends, he said those leases have terminated. There's also some fairly good language that's very heartening to landowners that says, look, companies, we're going to read these leases against you because we know that you're the big corporation here. You know what you're doing. Landowners don't. If there's any ambiguity here, we're going to find in favor of the landowners. But there's no direct ruling on force majeure in New York. I don't know of it it's only invoked here because of the moratorium. We have the only moratorium in the country. And people are, and so there isn't a lot of guidance here. And we'll have some rulings on it quickly because they're filing cases in Binghamton as we speak.
Okay, I have a question regarding property that may be leased around it. You, like my house, if they're all leased around and I don't sign a lease, do they have to file with the clerk that my property is considered leased as part of that? Or should I respond to the fact that I am now in the position of them coming under my property even though I didn't sign? Do I have to send them a letter stating, no, you can't do this? Is that clear? It's muddy.
Well, the mere fact that a lot of people around you have leased is certainly sobering and scary, but it doesn't necessarily mean that they can drill. It gets back to that concept of compulsory integration, which, again, nobody had heard of that 5 years ago either. I hadn't heard of it 3 years ago before I started studying this. There's a law that was passed by the state in 2005 that allows them, once they lease 60% of the land, then they have to apply to the DEC to compulsory integrate a spacing unit. You will get a notice of that if they're going to take that step. There will be a public hearing about that, and you'll be given some choices at that point, whether you want to lease, whether you want to do nothing, and I forget the alternative in the middle, and it has some monetary differences to which step you take. If they have enough land, and we haven't seen this in New York, they do it in other states under slightly different rules, but if they rule that they can proceed and compulsory integrate, then they're going to drill under your land whether you want them to or not. And there isn't much you can do about it. That's a very bad law. It shouldn't even apply to this type of drilling. The scientific explanation for that would take too long. We're trying to get the legislature to look at that law also. But they can't just drill under your land without at least going through that public notice and process of a public hearing and compulsory integration. At that point, once we start seeing more of if they can't drill now, so they're not applying for those permits, we're going to have to learn about that as we go along, as we have with most of this industry.
If I remember correctly, the hearing is in Albany. You have to go to Albany, and then you have to make the choice of one of the three compulsory integration choices within 30 days. And I think I read that on the DEC website. So you could probably read it for yourself there.
Hi, my name is Wayne Norris from Marcellus. A couple of my friends, they just got those force majeure things in the mail this week. And they said to me, what would you do? I says, don't cash the check, hang on to it. Or whatever. I didn't know where to go from there, but I says, they can't do anything if you don't accept the money. So that was my thinking on it. Now, my other point was, you were talking about, we've been under gas lease for 88 years. So, and our leases were, if they didn't drill the year you leased, it was extended to the second year, up to the 5th year. Then the 5th year, we renewed the lease, and you started another 5. That was back 70s, 80s, 90s. Well, this last time we did, and then again, you were talking about Triana, Mason-Dixon. Ultimately, they ended up with Chesapeake Bay by the time they got through switching them around. And we would get a notice of that in the mail. And but this last lease, I think this is the 5th year, I can't be sure. And we usually get it at this time of the year, and we haven't received our 5th payment yet. So I'm not sure just what we're going to get in the mail after hearing what my neighbors are getting. And I also think that they are leased under a different company than what we are. And I can't tell you now which company we're under, because I know our leases got bought up, and I'm pretty sure the checks were coming from Chesapeake Bay. The last year's did anyway. We we got paid so much each year. We didn't get a lump sum a lot of the guys, at least last year, they got a lump sum for 5 years. And so there's two different scenarios, a lot of different scenarios running around us right now. But like I say, this force majeure thing, that's new this year. And because I just said to the guys, I know what the other thing was. The guy that got the check sold his farm last year. He don't even own an acre of ground right now. And he got a great big huge check, you know. So he says, what do you do? I says, well, give it to the new owner. I don't know. But, and then we had the same thing. We sold one farm to the neighbor, and it was supposed to be transferred into his name, and it never has. This is what, the third year now that the check has come in my name. And the guy that bought the farm, he's never heard a thing about it. So I don't know what's the legality of that if you don't even own the property, you know. It would be almost like stealing, wouldn't it, if you took a check and you didn't own the land and you cashed it? I don't know. I mean, that'd be like walking down the street and picking up a check for $5,000 for and you don't own anything, wouldn't you think?
It tends to illustrate how complicated this gets.
Exactly.
With the companies changing leases, selling them, parceling them up. I hadn't really thought about that before. The landowners changed.
Yeah.
Yours changed. How did they know you?
The original person that leased with Phillips got her upfront money. Property was bought by another guy. He owned it for a year and a half or something, and the money went to him. He got it. Then I bought my land from him, and for some reason the checks still kept going to him, and it was irritating him because he called Columbia and all the other people involved and said, look, the property sold, here's the new owner. They never sorted it out. So for 2 years they sent him the checks and he would parcel it out to, I bought just one part of a giant old farm, several hundred acres. Yeah. And he would end up writing checks to 7 landowners from the money that I think it was Columbia was sending to him.
And the funny part of it is, when we made the sale with the neighbor, there was another farmer. He owns 2,000 acres, so he's probably got more than he knows what to do with. But he was never contacted by anybody that he had, purchased any land. In fact, I'm pretty sure he's got 3 farms right now that are paying gas leases on, but they've never switched him over to his name. And then he was one of those that got the force majeure thing.
Those leases should come up in the title search that's done by the attorney during the transfer.
Yeah.
The difference in the payment that you talked about at the first part was when there's a yearly payment, that's the delay rental. That if they don't drill 1 year, they have to pay the next year in order to keep the lease alive. I think they've pretty much abandoned that practice. It's 10 years old or so, and gone to the standard 5 years, lump sum at the beginning, and then if they can get you to sign the automatic renewal, there's a price that says for whatever we paid at the beginning, we send it to you again, and it's another 5 years. So you really want to watch out for that kind of automatic. As I said, the companies are learning. And they just lost a lawsuit on those yearly delay rental payments, so I doubt if we'll see any of them again.
Really? Yeah, I think maybe the ones that we got are probably the last of the delay rentals. And because everybody in our neighborhood that signed up, they laughed at it. They say, oh, we got a big check. They said, yeah, but the only thing is you're only going to get one check. And you won't get another one until 5 years is up. And then you'll get another one, which is happening now. And not only that, but the amount of money that come in was large enough so that it would throw their IRS income tax into another bracket. And so they had to pay income tax on the money, where when it come in on delay release, you could bury it in your farming and not be a big deal. So,
I haven't seen any recent leases with those yearly provisions.
not new, no.
No.
Everything comes through this lump sum.
Yep.
Yep.
We have another question up here.
Dill Otis, and I'm from town of Ledyard and town of Scipio. Quick question is, if the top of the agreement says geophysical permit and option to lease agreement, does that make it any different that it says option to lease? This is from 2003, and I just noticed now you've inspired me to look. Supposedly it expired second month, 28th, 2007. And I also did get that January 26th letter.
What's the next paragraph say after that one you started with?
After it says option to lease,
Yes.
grantor for consideration of sum of $1, that paragraph there?
Does it then say agrees that all those things we looked at, the leasing clause, is there a leasing clause there?
Well, it's pretty fine print. Take me a while to find it.
Well, that's another thing.
Yeah.
They're all so small and cramped. We could try to look at it, or maybe you could send it to me and I could look at it later. What I found is you really have to look at these things incredibly carefully. I was not a contract lawyer before this, but I've been a lawyer since '75, so I've seen a few contracts. These are very difficult to read. Incredibly small, very complex sentences, where right in the middle of a long sentence that could be a paragraph long, you're giving away the right to store gas. These things should be listed out, big print, so that you at least know what they're buying from you, because it's not just a little gas well. And that's the point I really tried to make at the beginning. But we can take another look at that.
David Wyman from Locke. I'm a leaseholder. With all this talk about leases and stuff, what is the potential of drilling at this point? I don't see much drilling going on. I'm 3 years away from a termination of a lease, and I'm wondering if I'll get out of it without any drilling on my property.
I didn't catch all of that.
I'm 3 years away from the end of a lease, and I'm wondering if I'll see any drilling. What's the potential for drilling in this next 3 years, do you think? Any crystal ball on that one?
Well, where we are in New York is that, as I said, Governor Patterson said there will be no drilling until at least June, because the DEC is revising this draft environmental impact statement that they issued back in September of '09. They had over 1,400 written comments about that because it was so, it had that many problems in it. So they're now reviewing all of those 1,400 comments, and the target date was June when they thought they were going to respond. There have been some statements by the new DEC Commissioner Joe Martens that tend to indicate that they're not going to be done in June because they have so much to respond to. He's saying late summer. So they have to issue another supplemental generic environmental impact statement. There will be a public comment period after that. They're saying 30 days. We're going to try to get more. They could be ready to issue permits in New York within this year. And so if they lift this moratorium, I think you'll see these companies coming at us very, very heavily. They're complaining that they can't do it now. They're trying to extend their leases, thinking that they're going to get in that time period. So unless something changes, and unless we can convince Albany to extend the moratorium, it could be within a year.
Charlie Ripley, town of Summer Hill. Oh, back in February, I think it was, that they had a debate down in SUNY Cortland, and they had a grid map of the units. Do you guys have any of that knowledge or any idea where we could get a copy of that?
That was probably Professor Tony Ingrafia that showed those.
Yes.
I can answer that. If I can jump in, you can call the DEC. I'll take.
Sorry to interrupt here, Joe, but I wondered the same. We have 13 gas wells above us on the hill between Atisco and Skaneateles Lake, and if you call or write Linda Collart, Collart, at the DEC, go to the DEC website, you can find that out, and she sent me the lease maps up on Rose Hill Road off of Route 20, and she sent me the spacing units, so I actually got the maps of them, so the DEC will give you that information, but it's not anywhere on the website. You have to ask for it, and she'll email it to you or send it to you.
But your question was about pooling units, spacing units? They don't, as far as I know, they haven't been defined yet. The companies, and as I said to the other question, if they're going to do one in your area, you're going to get notice about it. And clearly, one of the things that we've been able to do in the last 3 years is the media is much more aware of this problem. And it has been a problem in Pennsylvania. Certainly there are some people that say that it's been really good for certain aspects, but there are also people whose wells and lives have been ruined by this. And the media, 3 years ago, nobody talked about fracking. In December of '09, there was one bill in the state legislature. By last June, there were 30. This year, I think it's closer to 100. So the media, if they start defining and applying for pooling units, we hope that the media will cover it. And that, the more that people know about this, the more there are public hearings, the more that people can talk about it, the better. This is a very, very risky industrial process. And the way to understand that is to think about the Deepwater Horizon. They've drilled for all the easy oil and gas. It used to be those wells over near Olean, where my mother grew up, in the western part of the state. All they did was drill down, they hit a pocket of gas, they brought the gas up. They've got all that. So now we go further and further out on the edge of engineering hubris, and it gets more complicated. And despite all the promises that we have about how fracking never does this and never does that, last Tuesday they lost control of a well. Now, they were lucky because gas didn't come out, or very little gas came out. Only the polluted water came out. But hopefully we will know as we move into each stage of this, and people can have meetings in their towns and counties and discuss it. It should not. You shouldn't find out about a gas well when the 18-wheelers start driving past your house, 300 of them a day. That's what it is. And so hopefully we'll know about that. Hopefully we can keep the moratorium going as we learn more about this and as they try to say that they're getting safer. The gas isn't going anywhere. It's so cheap now that they don't want to sell it in the domestic market. They want to find another market for it. So there's really no rush here. That's one of the things we've tried to say.
Yes. Also. Oh, hi. I'm Bill Connick from Venice, and I belong to the Chesapeake one. Anyway, it's kind of naive. I got a check about a month ago. I sent it back with the signature with my wife and I on it that says we don't want to renew our lease, thinking everything was going to be fine. And I got a letter back just last week. It says, enclosed, please find check number, blah, 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 that we are returning. Pursuant to the attached oil and gas lease extension clause, it is lessee's option to extend this oil and gas lease. By payment rendered, Chesapeake Appalachia has elected to extend your lease. You, as a lessor, do not have any option to cancel this oil and gas lease, even by declining to cash the check. And I'm just saying, that what he said has nothing to do with it. So it's not a question, it's just what I got in the mail.
That's unfortunate, and it shows you how bad these original leases were.
Right.
And you probably are going to need to find a lawyer. I'm not trying to drum up business for lawyers. I don't advise people on signing leases. I advise it the other way, but there are lawyers that do this, and they're going to claim to extend your lease. And they've got all these tricks that I went over, and we've heard about them now. Force majeure, that's your delay rental, or your automatic extension check is what it is.
I didn't cash my checks either, but it was explained to me that the company was just fulfilling its obligation under the contract. So, you can cash it or not, it doesn't make any difference. And until the crucial time, then it makes all the difference.
I'm Bob Legal. I live in the watershed for Skaneateles Lake. I'm also a lawyer, and I'm concerned about the impact of essentially this industrial process in a residential zone, whether anyone is raising that issue. I'm concerned about that as an issue, whether anyone is challenging the propriety of signing a lease when it's essentially a violation of the zoning code. I wonder if either of you have had any experience. But before you answer, I want to applaud both of you for making this presentation. It's been excellent.
Thank you. It's a great question, too, because the issue of how much control towns and counties have is a very active one now. And in my opinion, and in several other attorneys' opinion, clearly zoning is, let me step back. New York has what they call home rule,
yes,
which means that in most mining situations, the state has all the authority. Although a town can prohibit surface mining, and that can be held up, you just can't regulate mining, and you can't regulate oil and gas. But clearly, you can have aquifer protection zones in your zoning code. You can have, I think that every town should make their zoning code very clear that you can't do industrial operations in a residential district. There are certain distances from many, schools, churches. I think that's a perfectly proper zoning power of a town to protect the health and welfare of its citizens. And I'm not alone in that, and many towns are doing that. And I think Skaneateles may be considering that. I'm not sure. But I think that zoning, it's certainly, you can have zones. That's what zoning is. Somebody couldn't come in and put a meat packing factory in a residential neighborhood. And it may already be specifically excluded in the zoning code, but you'd want to take a careful look at it. And if not, the town should look at it. But I know there are towns in southern Cortland County, I think it's Virgil, that have, the other thing that towns can do is pass road protection laws, because this industry ruins roads. The DEC estimates 8,000 truck loads per well. All that water has to get in there, all that equipment has to get in there, it has to come out. So towns really can do quite a bit, and they need to be encouraged to do more.
Are you aware, though, of anyone that is raising this as an issue, challenging the propriety of anybody entering into a lease? The particular thing that I'm concerned about is, say, where conservation easements have been granted for particular pieces of property that are already subject to a gas lease.
I don't know of anybody challenging a lease because it violates either an easement or a zoning provision. I think that's, I was down in Vestal about a month ago at the high school, and some of the pro drillers were saying this is a really good industry because it creates a lot of jobs. And one of the areas that it listed was, it creates a lot of jobs for lawyers. And we all have lawyer jobs, so it probably, it's going to have to get sorted out in the courts, I think, is unfortunate. Although I think the zoning, I know in the town of Preble, our zoning code, I don't see how they could do it in the residential zone that I live in because of what's excluded in the residential zone. How that gets played out if somebody tries to drill in it, we haven't seen yet. And I think that's up to the town or a neighbor. It's hard to get standing in a zoning case, but certainly if you're close enough to it, you have the standing. You might have to challenge that.
Are any of the towns denying access to water?
More and more of them are trying to consider it. I think about a year ago, the common thought was, well, towns can't do anything because of home rule. Then more lawyers, there's a couple of lawyers in Ithaca, Helen and David Slotky, who are running a not-for-profit that specializes in advising towns. Do we have something on that on the website? Or?
I think so.
I think that's on the GDAC website. Towns can do a lot here, and we need to encourage them. And what we find is that it takes a while to educate some of them. I think Skinny Atlas has been pretty well educated, but so encourage your town to protect you.
Hi, excuse me. I'm Bobby. We have a fireman senate, and we signed the lease with Chesapeake in September of '08 and got a lump sum, and the contract does have the force majeure in it.
It does?
It does. Mm-hmm. So we got the letter, but I looked and I thought the letter, I thought it said it might not state it, but if it does state it, then, and it states it. It says, it's a force majeure, and it doesn't say, a storm. It says laws, rules, regulations. So should we, it was the January 26th one. We didn't respond because it had the force majeure right in the contract. So should we now, or is it like a waste of time? Would it do anything, or are we sort of screwed?
I think you should send a response letter similar to the one that's on the website. Just, it's better than not doing it.
Okay.
Yours wouldn't, it's a 5-year lease, so you're looking at a couple years anyway.
Yeah.
Just because they use the magic term, remember Groucho Marx and the duck would come down, but I'm showing my age here. They just can't say force majeure. They have to have a legal basis for that. And that's what I was trying to say before, that the circumstances do not justify that. So that letter is sort of it's a scare tactic. I think it's an attempt by the companies to turn leaseholders against the moratorium, and you shouldn't view it that way. But just because they say that they have a right to use the force majeure excuse does not necessarily mean that that's a legally justifiable claim.
Okay, and also, but we didn't do it within 30 days. Does that really matter if you don't respond within 30 days?
No, I would send it.
Okay, thank you.
Yes, I would send it. It's certainly safer to do that than not, no matter how much time.
My name's Ron Jones from Aurora. I signed a contract in May of '09 that had no force majeure in that, but I got the letter. Should I still send them a letter?
Oh, yes, specifically. And you'll see that the form letter has one paragraph that says, that reminds them that isn't in your lease. People have to not send that if they do have it in their lease, but that puts you in a much stronger situation, and they should be reminded of that. And so, yes, you really should send a letter, because that shows you how weak this claim is and how little they care about you, because they didn't even look at your lease. They just sent it out to every lease they had because it's easy for them. And it shows you that they don't really, this is not a responsible letter, in my opinion, because that shouldn't have gone to you or the two fellows I know over in Marcellus that got it as well that didn't have it in their lease.
Well, should I use the letter that you have on the website?
Yes.
Or should I add?
I think the letter on, I know the letter on the website fits that circumstance, and there is a specific paragraph that reminds them that it isn't in your lease. And yes, I would send that if I were in your shoes.
Someone up here.
Even I can hear it.
Hello, my name's Bill Guptill, and I'm from South Onondaga, right over next to the Onondaga Nation. I have a lease from '06, so mine will be up, it looks like it's actually said it restarted in September, so it'll be September of this year mine will be up. I did not cross out the automatic renewal here. Extension of term option. So that puts me in the situation, I believe, as the gentleman over here, that I should have a check coming this fall and puts me there. And this extension, it says it's for an additional 5 years from the original primary term, but then it doesn't say it goes on after that. So in a worst case scenario, am I caught for the next 5? And then it'll be a termination end for me?
Yes. And I think there's going to be court cases that test the legality of those automatic extensions. There's a general rule of real estate law. I'm thinking back to Property 101 in 1971, so I don't remember much of it, but that you can't have encumbrances on real property that run forever. It's a very complex, I shouldn't go into it, but I would still attempt to return the check. I'm sure there will be cases in the next couple of years that test whether or not those automatic renewal clauses are fair. We just read about a case in Pennsylvania within the last week where a federal judge allowed a case claiming fraud against Cabot Oil in obtaining the lease to proceed. Now, they didn't win, they just didn't throw it out. I'm trying to get some of the papers from that case to learn more from it. Many of the clauses in these contracts are unconscionable, and courts are taking a harder look at them, and enough people are getting together with lawyers to do it so that it doesn't bankrupt you. We know lawyers are expensive. So that may be tested between in the near future. I would still return the check if you want to get out of it and see whether or not they have it together to keep coming back at you. But did the landman carefully explain that to you?
No. And I was also given that prime example of the thing you used of my grandfather's. We had some wells drilled in the town of Onondaga back in, Rick, when were those, in the 70s? Up on Fishers and stuff, and there's a little stand, the podium she stood in front of up there is...
Yeah, there's one about a mile from my house that you could put a flower garden around and it wouldn't matter.
Right, and so you're figuring, okay, we're, roadway in, a piece of pipe we can fence out and put it in the pasture and will be no big deal.
Right, and particularly, the farmers I know up there, it was common, this is easy money, it's no encumbrance, take the money. It's hard, it's impossible to turn that down at the time. Now we've all learned a lot.
Yeah. And I've seen since I was young the stuff that was, there's been leases in our area, like Wayne said, from the 70s, and they kept paying and nothing ever happened, so you were like...
Yep. Well, now they want something to happen.
Thank you.
I'm Lou Lego, and we're here in Auburn. And we're in a situation where one of the situations we're in is where the well is not on our property. They've already drilled the well. But we're in the circle that goes around the well, and a portion of our land is on that. We get no correspondence whatsoever on this. We did sign saying that they could extract gas from under our land, but we hear nothing anymore about this. We also have leases on our land which we're working on getting canceled, but this one we seem to have no control whatsoever on. What do you do in that case?
How far away is it?
It's maybe 300 yards from the edge of our property.
Well, I would certainly have my well tested, and so that you know that it's clean now. I mean, I know you know. Do you have a well?
Oh yes, we have several wells on the property.
You want to have some baseline testing, because otherwise they'll come back and say that methane that comes up when they start fracking was always there. So I would get my well tested. If it's going on somebody else's property, there isn't much that the neighbor can do except try to talk with that neighbor about concerns. They may not have much control at all over siting. One of the things that I learned, again, Mike is the one who really got me going in this, because he had such an ordeal, and he got into the clerk's office, and really, this is not an easy process. But one of the leases that he found was a 2008 lease in southern Cortland County that the DEC, this is another conflict that the DEC has. They have a three-way conflict. The law requires them to regulate gas drilling, that's pretty understandable, promote it. So they're supposed to promote something and then regulate it on the other side. And then they're leasing state forests for profit. Those are the same three conflicts that we saw that led to the Deepwater. So in 2008, the DEC signed this very, very protective lease for state forest, with all these protective clauses that I'm sure most of you would really want to have in any lease. For instance, wherever you drill, you have to get written permission from me. You can't cut a tree without my written permission. If you don't have those kind of clauses and you signed one of those leases that they put in front of you and said, this is standard, don't worry about it, you have almost no, even the landowner themselves has very, very limited protection for where they can do things and what they can do. It's not a good situation. It's why these leases need to be, if you're going to lease, you want to have a better lease than you have now.
Okay, I'm coming around. Who had their hand up?
Hi, my name is Barbara King. Given what you just said, in 2007 when I attended a meeting in Cazenovia with Bruce Denninger and company from the Attorney General's office in Binghamton, I asked the question why there wasn't protection for the landowner, for the New York State taxpayer, for consumer protections that would release those unaware of fracking and those techniques, those who had signed vertical drilling, just exclusive vertical drilling drilling leases with companies, why those protections couldn't be extended by the Attorney General's office. And I was going to ask you, if Friday you could ask Eric Schneiderman to cut us some slack, because the awareness of the last couple of years has been that the dangers of this new technology weren't relevant to when most of us signed our leases in this area for either Black Trenton or just vertical drilling. And do you know of the recent developments of him suing the federal government?
Well, he announced last week, I think. He made some very promising statements during the Democratic primary, seemed to back off them a little bit during the general election. And as we say in the business, the jury's out, I think. But Last week, he looked at some of the regulations that the Delaware River Basin Commission was contemplating and said, these aren't good enough, and if you implement them, I will sue you. So we're hopeful that he'll get more involved in this. This is clearly a consumer protection, citizens' rights. Some of the answers, we've been trying to talk to lower people in that office, the Attorney General's office, and generally the answers we've been getting, well, these are private contracts and the people made them, and what can we do about them? What we hope to show him, because it's very clear, there's a pattern in practice here, and it's deception. It's that stuff that was found in that Ohio crib sheet. Don't talk about the chemicals. If they ask about this, change the subject. There's a lot more in this. This is a 5-page recipe for deception, I could call it. And so there is a pattern in practice here that people weren't told what they were giving away, weren't told that there was this automatic renewal, weren't told. These things are scary when you read them. They weren't told that you could store gas under your property. Not too many people I know want natural gas stored under their property. And so, yes, we hope to push him. That's why we're going there.
Well, also there's the problem of waste injection. So, that further complicates when a company come on and just inject their waste fluids in a spent well. But can't the Attorney General's office give a time, an allowance of time for those lease owners in New York State who want to release themselves of these leases? Why can't there be a window of opportunity for us?
I think there should be, and certainly deep injection wells are a very, very serious threat. We've seen that in Arkansas they were causing earthquakes, and when they stopped it, this produces millions of gallons of radioactive, chemically contaminated water. It comes back up with strontium, barium, lead, chromium. They use hundreds of chemicals in the frac process. We're just now beginning to learn some of them. Hydrochloric acid, there's a lot of carcinogens, a lot of endocrine disruptors. These are very dangerous chemicals. We don't even know what they are. And so in injection wells, there's a little bit of control over, because that is one aspect of the federal law that still applies, and they have to get an EPA permit for that. But they tried to put one over near Keuka Lake a year ago. The people there got together and stopped it. But New York is not prepared for that. New York really needs a lot of strengthening of our laws and regulations if this practice is going to come here. And I hope we can help move the Attorney General. And those are good ideas.
I'd like to just comment. You raised a real good point right off the bat about the state giving some guidance to us. If you read the DEC lease, as I have, it's on the Cortland website, the county clerk's website. You can read the whole lease. It's 90 pages. And you compare that to the standard 3-page lease. It's a real eye-opener. The state knew in 2006 all these details. Like, they're going to measure the gas at the wellhead, and it's going to be calculated according to, the state's going to get paid the market price, and there's no deductions. But it just goes through this, every single item that we're concerned about, and the rest of us were just left to fend for ourselves. So the state did know about it, and you got to ask, why wasn't any guidance given to the rest of us? That's been something that I've been asking, and I'm not getting a satisfactory answer to that either.
That lease can only be extended upon mutual written approval, and then only for 2 one-year periods. Any of you have leases like that? Can't be assigned to any of those other companies without written approval. The well siting plan must be developed by the company and approved in writing. The records is very. It's if there's such a thing as a good lease, this is one. And they knew about it. They fought for it. Now, you know, this was a 7,000 acres or something, but if they would just put on their website, these are clauses that would protect you better, and you could go to it. That's what our public servants should be doing for us, and that's what we're going to Albany to push for. I had a meeting last Tuesday with Barbara Lifton, who's one of the assembly people at the lead of trying to get us some protections about leasing and about those kinds of things. So I agree. The Attorney General should be doing more. The DEC should be doing more. The problem is their staff has been cut so radically. That's why Pete Granis was fired last November, because he had the nerve to tell the governor, you cut my staff so much, I can't properly regulate this industry. And he got fired for that. But they should be doing more, and we have to keep asking them to do more, and we have to ask more of our legislators, because that's where the real power is here. I don't have we're not getting any clear signals from the governor's office. So, but you're right, they should be doing more for us.
Can you lobby for a severance tax?
It's idiotic that we would be one of the very few states that doesn't charge what comes out of the well 3, 4, 5%. What I hear from Albany when I go there and ask questions about this many times is, everybody knows we need the money and the jobs. Well, the jobs go to roustabouts from Texas and Louisiana. The money is here and then goes. If these wells are going to produce, there ought to be a tax. That might get us something. That's not even, you don't even hear that being discussed.
We have time for one more quick question because it's getting on till 9.
I wanted to put some thoughts together and then ask 2 questions. One, in the Ithaca area, I think it was Dryden, it was like a year ago or so, representatives from the Attorney General office came, and one of the things that I had asked about was terminating not leases at the end, but leases, you know, as they've been signed. In any case, he said something very critical that was brought up just a little while ago. The attorneys, when this started, didn't really know what they were getting into, so they weren't advising their clients properly. So this is mind-boggling to me, because it seems to me, and I want to tie in the deception letter, because the letter alone shows proof, and I'm sure you're going to bring this up at the Attorney General's office tomorrow, on Friday. I mean, there is clearly a deceiving pattern that I think if I was a lawyer, I mean, they need to be sued. They need to be stopped, which therefore goes to my questions. One is, you mentioned, sir, that Fortuna did not, you didn't terminate the lease with Fortuna. There were several companies.
I terminated it by filing my own termination letter. They never sent me a release.
But is that not important? Because it seems to me for them not to also agree in that, they can come back and do something sneaky.
No, the law is very clear that once you send the notice letter and they fail to respond in that 30 days, you can terminate it by filing it.
Okay, and the last thing is, and this is something that is very dear to my heart, a lot of people around New York State are pushing for a ban, for the state to ban hydrofracking, because we really need time, because it's clear from everything that you said and everything everybody else is saying that we've been deceived, and now we're learning this information, and they work very fast, you know? So this is all very clear. So I'm wondering if a state ban, because several other states now have banned hydrofracking, if that is something that we should be pursuing, something that's achievable, because several areas like Dryden outside of Ithaca has banned hydrofracking. I think Ulysses has. New Jersey has banned hydrofracking. Pittsburgh has banned hydrofracking, and I think Rochester has. So I think there's a lot of power in banning, and not just symbolicness. Can you speak to that? Is that something we could do legally? And thank you again for your time.
The state could clearly ban it. And personally, I'm very much in favor of that. I don't see how this can be done. They want to turn the Finger Lakes into Texas. And there's even people in Texas where I read an article lately that some comedian had 3 things about Texans, and the only one that she could remember was that they hate people that don't like oil and gas. Even in Texas, there's a resistance movement now because of the air pollution and water pollution. This cannot be done. I think it's proven almost weekly in Pennsylvania, this cannot be done safely because they don't know what they're doing. Chesapeake, after that well blowout last Tuesday, had to shut down all of their fracking operations in Pennsylvania because they don't know what happened. And yet, I've debated several industry people, and they're always telling us this is safe, there's never been a problem, it should be banned. That's my opinion. And I think it's something that I know there are several different versions of ban bills in the legislature. It's something we really need to focus on in the next couple of months because we know they only work in Albany until about June and then they go home. So yes, that's what we need to get from our legislators, our assembly people and our senators. And put it in front of the governor and see what he's really going to do about this.
There's a rally May 2nd in Albany for that.
Yes.
Okay, I think we're wrapped up. I want to say again, thank you to Auburn Public Theater for donating the space for this meeting. There are some more lease workshops coming up in May. The Soil and Water Conservation District of Cayuga County is sponsoring something, not quite sure when, and a couple other ones just came through my email box too in this larger region for leasing workshops. So gdac.wordpress.com, once again, go there and they will be listed there on the calendar. Or also, there's a calendar, and this is pretty easy, gasmain.org. And that you can go to the calendar there and list all kinds of fracking events. They try to get everything on there. That's gasmain.org. And thank you again, Joe and Mike, for your work.
If people here are interested in going to the rally in Albany on May 2nd, I'm organizing a bus from Syracuse, so come see me afterwards.